331. 62 feet Federal Equity Procedure. 56. Will entertain such a bill. An equity rule promulgated January 23, 1882, provides that every bill brought by one or more stockholders in a corporation, against the corporation and other parties, founded on rights which may properly be asserted by the corporation, must be verified by oath, and must contain an allegation that the plaintiff was a shareholder at the time of the transaction of which he complains, or TL, that his share had devolved on him since, by operation of law, and that the suit is not a collusive one, to confer on a court of the United States jurisdiction of a case, of which it would not otherwise have cognizance. It must also set forth with particularity the efforts of the plaintiff to secure such action as he desires on the part of the managing directors or trustees, and, if necessary, of the shareholders, and the cause of his failure to obtain such action. 1. The principle embodied in the rule was announced, in an opinion in the Supreme Court in the year 1881, in which the court, speaking by Mr. Justice Miller, said, "We understand that doctrine to be that, to enable a stockholder in a corporate 10N, to sustain in a court of equity, in his own name, a suit founded on a right of action existing in the corporation itself, and in which the corporate 10N itself is the appropriate plaintiff, there must exist as the foundation of the suit some action, or threatened action of the managing board of directors or trustees of any corporation which is beyond the authority conferred on them by their charter or other source of organization, or such a fraudulent transaction, completed or contemplated by the acting managers, in connection with some other party, or among themselves, or with other shareholders, as will result in certain injury to the corporation, or to the interests of the other shareholders, or where the board of directors, or a majority of them, are acting for their own interests, in a manner destructive of the corporation itself, or of the rights of the other shareholders, or where the majority of the shareholders themselves are oppressively and illegally pursuing a course in the name of the corporation which is in violation of the REDHTS of the other shareholders, and which can only be restrained by the aid of a court of equity. Possibly other cases may arise in which, to prevent irremediable injury, or a total failure of justice, the court would be justified in exercising its powers, but, L. Equity Rule 94. 5. 7. PRTIS 63. The foregoing may be regarded as an outline of the principles which govern this class of cases. But, in addition to the existence of grievances which call for this kind of relief, it is equally important that before the shareholder is permitted in his own name to institute and conduct a litigation which USUR LLY belongs to the corporation, he should show to the satisfaction of the court that he has exhausted all the means within his reach to obtain, within the corporation itself, the redress of his grievances, or action in conformity to his wishes. He must make an earnest, not a simulated, effort, with the managing body of the corporation, to induce remedial action on their part, and this must be MLD apparent to the court. If time permits or has permitted, he must show, if he fails with the directors, that he had made an honest effort, to obtain action by the stockholders as a body, in the matter of which he complains. And he must show a case, if this is not done, where it could not be done, or it was not reasonable to require it. The efforts to induce such action as complainant desires on the part of the directors and of the shareholders when that is necessary, and the cause of failure in these efforts, should be stated with particularity, and an allegation that complainant was a shareholder at the time of the transactions of which he complains, or that his shares had devolved on him, since by operation of law, and that the suit is not a collusive one to confer on a court of the United States jurisdiction in a case, of which it could otherwise have no cognizance, should be in the bill, which should be verified by affidavit. 157. Suits against corporations, who to defend intervening stockholders or suits intended to reach or affect the property or corporate rights and interests of a corporation should be brought and prosecuted against it in its corporate name, and it is a rule of universal application that a corporation, when sued, must appear and defend in its corporate name and capacity, under the direction and control of its lawfully constituted managing officers, who are trustees for the stockholders. It is neither the duty nor the right of stockholders to defend suits against corporations of which they are members, and it is only in a clear case of conspiracy or fraud. L. Hawes v. Contra Costa Water Co., 104 US 450, 462. 64 Feder Point Al Equity Procedure. 57. Upon the part of the officers of a corporation, to sacrifice the interests of the stockholders, or a fraudulent failure on the part of the officers, to defend a suit brought against a corporation, that a stockholder will be allowed to become a party defendant for the purpose of protecting his own interests. The doctrine upon this subject was, in 1864, stated by the United States Supreme Court, speaking through Mr. Justice Nelson, as follows: as these two stockholders, though not made defendants by the bill, were permitted, by leave of the court, to appear and put in answers in the name of the Milwaukee and Minnesota Company, it is material to inquire into the effect, to be given to them. That they cannot be regarded as the answers of the corporate body is manifest, as a corporation must appear, and answer to the bill, not under oath, but under its common seal. And an omission thus to appear, and answer according to the rules, and practice of the court entitles the complainants to enter an order, that the bill be taken pro confesso. A further objection to the practice of permitting a party to appear and answer in the name of the corporation is the inequality that would exist between the parties to the litigation. The corporation not being before the court, it would not be bound by any order or decree rendered against it, nor by any admissions made in the answer or stipulation that might be entered into by the parties or their counsel. It is thus apparent that, while the name of the corporation is thus used as a real party in the litigation so far as the rights and interests of the complainants are concerned, it is an unreal and fictitious party so far as respects any obligation or responsibility on the part of the respondents. It is insisted, however, that the directors of the company refuse to appear and defend the bill against them, and for the fraudulent purpose of sacrificing the interests of the stockholders, and hence the necessity, as well as the propriety and justice, of permitting the defense by a stockholder in their name. Undoubtedly, in the case opposed, it would be a reproach to the law, and especially in a court of equity, if the stockholders were remediless. But in such a case the court, in its discretion, will permit a stockholder to become a party defendant for the purpose of I. Bronson v. Railroad Co., 2 Wall 323, Trust Co. v. Railroad Co., 43, 283, Forbes v. Railroad Co., 2 Woods, Fed. R. 14. 57, Parties 65. Protecting his own interest against unfounded or illegal claims against the company, and he will also be permitted to appear on behalf of other stockholders who may desire to join him in the defense. But this defense is independent of the company and of its directors, and the stockholder becomes a real and substantial party to the extent of his own interest, and of those who may join him, and against whom any proceeding, order or decree of the court in the cause is binding, and may be enforced. It is true the remedy is an extreme one, and should be admitted by the court with hesitation and caution, but it grows out of the necessity of the case, and for the sake of justice, and may be the only remedy to prevent a flagrant wrong. One in an elaborate opinion at Chambers at Austin, Texas, in 1872, vacating, as improvidently made, a previous order allowing individual stockholders to intervene for the protection of their interests, after stating the case, Bradley, Circuit Justice, states the doctrine and the principles upon which it rests. Thus, in order properly to understand the questions thus raised, it will be necessary to examine the general character of suits and proceedings in equity against corporations in their relations to the interest of the stockholders, and the general right of the latter to intervene therein, pro interesse suo. A commercial or other business corporation is constituted for the specific purpose of suing and being sued, granting and receiving, buying and selling, and doing other business in a corporate name and capacity, totally distinct from that of any or all of its members considered as individuals. A corporation is a person. Its property is not the property of its stockholders. Its rights are not their rights. They have only an indirect interest therein. The rights of a stockholder are to meet at stockholders' meetings, to participate in the profits of the business, and to require that the corporate property and funds shall not be diverted from their original purpose. If the company become insolvent, it is the right of the stockholders to have the property applied to the payment of its debts. I do not know of any other rights, except incidental ones, subsidiary or auxiliary, right to these. Of course, a stockholder has ordinarily a right to a certificate for his stock, to transfer it on the company's books, and to inspect these books. For the invasion of I. Bronson v. Railroad Co., Supra. 5. 66 Federal Equity Procedure. 57. These rights by the officers of the company, he may sue at law or in equity, according to the nature of point the case. But all remedies for injuries to the property or rights of the company must be prosecuted in the name of the company, and all demands against the company must be prosecuted against the company by name, unless its officers or agents, by fraud and misrepresentation, have rendered themselves personally liable. A stockholder, in his character of stockholder, cannot sue, nor, unless specially made liable by the charter, can he be sued for any of the company's transactions. There is one case, and one only, in which he can interpose, and that is where the officers and managers of the company, by fraud and collusion with third persons, are sacrificing or are about to sacrifice, and betray the interests of the corporation. For such breach of trust and conspiracy he can call the guilty parties to an account in a court of equity. It is true that the complainants filed the bill in this case on behalf of themselves, and of all others being stockholders, creditors, or bondholders of the corporation defendant who might desire, or be entitled to intervene. But it was never contemplated, nor is it the proper practice, that the persons embraced in that category should intervene to set aside the proceedings, or to interpose obstacles to the progress of the suit. The complainants, by suing as representatives, opened the door to all other parties named to come in and take the benefit of the proceedings and decree, not to oppose and nullify them. In a suit so instituted, parties may come in and prove their claims or status, and participate in all the dividends and benefits to be derived from the suit. Rival creditors, by proceedings before a master, may control the priority of their respective liens, and creditors or stockholders may contest the validity of the claims of other creditors and stockholders, but all in subordination to the general object and purpose of the suit, to obtain an administration of the company's assets and property. To be allowed to intervene as general defendants and contestants is another and a different thing. This can be admitted only upon the ground before referred to wit, having an interest in the results as a stockholder or otherwise, and being able to show fraud or collusion between the plaintiffs in the suit and the officers of the company having charge of its interests. A suggestion, in the 59.J Part is 67. Progress of the suit, that an officer of the court is disposed to act fraudulently, or that the court has made an injudicious order, will not be a sufficient ground to allow such a party to intervene. Indeed, it is questionable whether, in any case, where a suit is properly instituted against a corporation, a stockholder of that corporation can, even on a suggestion of fraud on the part of its officers, come in by way of intervention as a party to that suit and seek to defend or control the proceedings. An original bill would rather seem to be the one proper mode of proceeding. And it is in the discretion of the court whether or not to permit a stockholder to become a party defendant in any case where he is not made such by the bill. I-58. Same. Officers made defendants for discovery. In a suit in equity against a corporation, its directors, officers, and members may, at the election of the plaintiff, be joined as defendants for the purpose of obtaining from them a discovery-0 an oath of facts to sustain the case made by the bill, and it is not necessary for the bill to allege that such directors, officers, and members are alone cognizant of the facts of which discovery is sought. But it will be sufficient, if it appear, that the facts averred in the bill are material to the relief sought against the corporation and rest in the knowledge of such directors, officers and members. 259. Parties to ordinary foreclosure suits, it is a rule, that to a bill filed to foreclose a mortgage, the mortgagor, and all encumbrances, both prior and subsequent, whether by mortgage or judgment, and all persons having an interest in the property at the commencement of the suit, should be made parties, and, while the rule is not of universal application, there are three very cogent reasons why it should be enforced when at all practicable, namely, 1. They are all interested in the account to be taken of the various sums of money to be decreed a charge upon the property, and the fixing of the amounts and priorities of the liens of such sums of money, and the proper L. Forbes v. Railroad Co., Supra. 2. 1 Daniel, 186, 187, Bronson v. Railroad Co., 2 Wall 283, Brumley v. Manufacturing Co., 1 Johns. Ch. 363, Vermilia v. Bank, 1 page, 38, May v. Iron Co., 9 page, 193, Story, Eck. Place, Seconds 235. 68 Feder Point Al Equity Procedure. 51. Cheyenne of the burdens, to be borne by the different parts of the property, and, 2. In order to prevent a sacrifice of the property at the foreclosure sale, and realize its full value, it is necessary that the purchaser at such sale should acquire a clear, unencumbered and indefeasible title, and such result can be attained in no other way than by a decree, which shall foreclose and conclude all persons in interest, and shall invest the whole title of the property in the purchaser, and, 3. The junior encumbrances are entitled in equity to redeem the prior encumbrances, and the mortgagor is entitled to redeem them all one in one of the cases the defendants, mortgagors, to a bill of foreclosure stated in their answer that certain legacies were a charge on the property superior to the plaintiff's mortgage, and that the legatees should be made parties to the suit, and Chancellor Kent, in disposing of the question thus raised, said, these legatees, whose legacies, as stated in the answer, were a prior encumbrance, ought to be made parties, in order to prevent a sale of the premises from being deceptive, or embarrassing to the purchaser and injurious to the rights of the defendants, and to enable the plaintiffs, if necessary, to redeem the land from the prior encumbrance. In cases of a strict technical foreclosure there may be no injury in leaving a prior encumbrance undisturbed, but where the land is to be sold, it will seem to be essential to the interests of all concerned, and necessary to prevent a sacrifice of the subject at the sale, that the certainty, value, and extent of the prior encumbrance, made known by the pleadings, should be ascertained and declared. It is the general doctrine of this court, that all parties having an interest in the subject matter of the suit should be before the court, to the end, that their interest may be embraced by the decree, and that once it may terminate all controversy depending on the various rights. In this case it is said, that the legacies are a charge on the whole land, of which the interest mortgaged is 1 Grant v. Senex Lifeins. Co., 121 Ensworth v. Lamert, 4 Johns. Ch. US 105, Finley v. Bank of United 60, Cook v. Mancius, 5 Johns. Chapter 93, states, 11 Wheat 306, Mendenhall v. McGowan v. Yerkes, 6 Johns. Chapter 450, Hall, 134 US 559, 571, Caldwell v. 1 Daniel. 307, 308, 309, Jerome v. McTaggart, 4 Pet 202, Sutherland v. Carter, 94 US 734, H11. Gann v. Walker, Lake Superior Ship Canal, Railroad 14 How 28 237, McClure v. Adams, and Iron Co., Fed. Cass. Number 13643. 76 Fed. R 899. Haynes v. Beach, 3 Johns. Chapter 459. 60. J Part is 69. Only an undivided part. It may be necessary in that case to apportion the charge, and settle the proportion, that the inter LST of the mortgagors ought to bear before a sale can be discreetly ordered, or the purchaser safely and intelligently buy. 1. The Supreme Court of the United States, in reversing a final decree upon the foreclosure suit of a junior mortgagee, and remanding it for the purpose of making the prior mortgagees parties to the suit, said, it is not enough, that a court of equity causes nothing but the interest of the proper party to change owners. Its decrees should terminate, and not instigate, litigation. Its sales should tempt men to sober investment, and not to wild speculation. Its process should act upon known and definite interests, and not upon such as admit of no medium of estimation. It has the means of reducing every right to certainty and precision, and is therefore bound to employ those means in the exercise of its jurisdiction. 2. It is the usual practice to insert in foreclosure bills an interrogatory to the mortgagor requiring him to answer whether or not there are any other, and if any, what, encumbrances, and if he answers stating any, the encumbrances are made parties to the suit. 3. 60. Parties to bills. To redeem a bill, to redeem a mortgage should be filed by the mortgagor, if he be living and has made no assignment or transfer of his equity of redemption. If the mortgagor be dead, the bill should be filed by his heir at law or devotee, and if he has by will vested the property in testamentary trustees, they are the proper parties to bring the bill. If the mortgagor has fully assigned his equity of redemption, then he is not a proper party, and the bill should be brought by his assignee. The mortgagee, if living, is the only indispensable party defendant to the bill to redeem, and if he be dead, his heir at law, or his devotee or trustee in whom the legal title to the mortgaged premises is vested, must be a party defendant, so that the title may be bound by the decree of foreclosure, and passed to the purchaser at the foreclosure sale, and the executor or administrator of the mortgagee should also. Down v. Yerkes, Supra. To Caldwell v. Taggart, Supra. S. Haynes v. Beach, Supra. 4. 1 Daniel, 304. Dexter v. Arnold, 1 Some 109, Fed. Cass. Number 3857, Stories Ec. Place, Sex 182, 183, 184, 185. 70 Federal Equity Procedure. 61, 62. Be made a party defendant, because the funds secured by the mortgage is personal assets in the hands of the person L representative for the payment of debts, and if the mortgagee has assigned the mortgage, his assignee should be made a party defendant in his stead. 1. If there are junior encumbrances, they should be made defendants, because they have the right to redeem either or all of the antecedent mortgages. 261. Class suits. Numerous parties. An equity rule provides, where the parties on either side are very numerous, and cannot, without manifest inconvenience and oppressive delays in the suit, be all brought before it, the court in its discretion, may dispense with making them all parties, and may proceed in the suit, having sufficient parties before it to represent all the adverse interests of the plaintiffs and defendants in the suit properly before it. But in such cases the decree shall be without prejudice to the rights and claims of the absent parties. 8. This rule is declaratory of the rule as it previously existed, the only change made being the provision in the last clause, that the decree shall be without prejudice to all the absent parties. 462. Parties where real property is subject to successive estates. In all cases in which an estate is claimed against another, by a person deriving title under a settlement, made either by deed or will, it is necessary to make all the persons claiming under the settlement parties to the suit down to the person entitled to the first vested estate of inheritance, either in fee or entail, inclusive, but it is not necessary to bring b. For the court those claiming in remainder a reversion, the first person in existence, who is entitled to a vested estate of inheritance is sufficient to represent all remainders behind him. 5. I. Stories Ec. Place, Sex 188, 189, 190, 191, 192, Whitney v. McKinney, 7 Johns. Chapter 145. 2 United States 11 v. Sturgis, 1 Payne, 525, Fed. Cass. Number 16414. 1 Daniel, 306, Stories Ec. Place, Seconds 186. 3 Equity Rule 48. 41 Daniel, 331 to 337, Stories Ec. Place, Sex 97, 120, 121, 122, West v. Randall, 2 Mason, 181, Fed. Cass. No. 17424, Beard v. Oliver, 2 McLean, 267, Fed. Cass. Number 11115, Smith v. Swamstead, 16 How 288. 51 Daniel, 316, 817, 318, 319, Redsdale, 6th Ab edition, 19, I, 200, Insurance Co. v. Cammett, 2 ed. W. Chapter 127. 2 JL.I Addox Chapter 146. 63, 64. Parties 71. 63. Nominal parties. No person should be made a party, either as plaintiff or defendant, to a suit in equity, who has no interest, beneficial or otherwise, in the subject matter, and for or against whom, if brought to a hearing, there can be no decree, and upon this principle, persons who are mere witnesses, and may be examined as such, ought not to be made defendants for the purposes of discovery. But to this rule there are some exceptions. Officers and members of a corporation may, under certain restrictions, be joined as defendants in a suit against the corporation, for the purpose of discovery, and where the bill alleges fraud in connection with the transaction under investigation, and it is shown that the agents, attorneys, and solicitors of the principal defendant participated in the fraud, they may be properly made defendants. 1. It is provided by an equity rule that, where no account, payment, conveyance or other direct relief is sought against a party to a suit, not being an infant, the party, upon service of the subpoena upon him, need not appear and answer the bill, unless the plaintiff specially requires him so to do by the prayer of his bill, but he may appear and answer at his option, and if he does not appear and answer he shall be bound by all the proceedings in the cause. If the plaintiff shall require him to appear and answer he shall be entitled to the costs of all the proceedings against him, unless the court shall otherwise direct. To the courts of the United States will not suffer their jurisdiction to be ousted by the mere joinder or non-joinder of formal parties, but will ever proceed without them, and decide upon the merits of the case between the parties, who have the real interests before them, whenever it can be done without prejudice to the rights of others. 3. 64. Parties jointly and severally liable. An equity rule provides that, in all cases in which the plaintiff has a joint and several demand against several persons, either as principals or sureties, it shall not be necessary to bring before the court. 11 Daniel, 393-401. 2 Equity Rule 54. 3 Wormley v. Wormley, 8 Wheat, 451. Removal cases, 100 U.S. 457. Barney v. Latham, 103 U.S. 205, Harter v. Kernachan, 103 U.S. 562, Taylor v. Holmes, 14 Fed.R 49, L. Maryland v. Baldwin, 112 U.S. 490. 72 Federal Equity Procedure. 65. As parties to a suit concerning such demand, all the persons liable thereto, but the plaintiff may proceed against one or more of the persons severally liable. 1. This equity rule is a literal copy of the TREATISE signed of the Orders of the High Court of Chancery in England of 1841, and creates an exception to the general rule in equity, which requires the plaintiff to bring before the court all persons legally or beneficially interested in the suit. To another exception to that general rule is that where two persons jointly owe a debt, and one of them is beyond the process of the court, and equity has jurisdiction of the subject matter, a decree may be taken against the debtor before the court and subject to its jurisdiction for the whole amount of the debt. 3. 65. Objection for want of parties, when and how raised. Whenever a want of parties appears on the face of a bill, and there are no allegations in the bill showing a sufficient excuse for the omission of such parties, the defect may be taken advantage of by demurrer. Otherwise the question should be raised by plea or answer, averring the facts necessary to show the defect of parties, and the names and description of the persons whose omission from the bill has caused the alleged defeat of parties. For an equity rule provides that, where the defendant shall, by his answer, suggest that the bill is defective for want of parties, the plaintiff shall be at liberty, within 14 days after answer filed, to set down the cause for argument upon that objection only, and the purpose for which the same is so set down shall be notified by an entry, to be made in the clerk's order book, in the form, or to the effect following, that is to say, set down upon the defendant's objection for want of parties. and where the plaintiff shall not so set down his cause, but shall proceed therewith to a hearing, notwithstanding an objection for want of part is taken by the answer, he shall not, at the hearing of the cause, if the defend. 1 Equity Rule 51. 2. 1 Daniel. 284, 285. A 1 Daniel. 258, Lewis v. United States, 92 U.S. 618. 4 Edisdale, 6th Am edition, 206, 207. 1 Daniel, 384-388, Story v. Livingston, 13 Pet 359, 375, Carey v. Brown, 92 U.S. 171, Saji v. Thomas, 3/11, Fed. Os. Number 12633, Equity Rule 53. 66, 67, Parties 73. And subjection shall then be allowed, be entitled as of course to an order for liberty, to amend his bill by adding parties. But the court, if it thinks fit, shall be at liberty to dismiss the bill. 1 And if the bill be dismissed for want of parties it should be without prejudice. Z 66. Same. Objection at the hearing. It is provided by an equity rule that, if a defendant shall L, at the hearing of a cause, object that a suit is defective for want of parties, not having by plea or answer taken the objection, and therein specified by name or description of parties to whom the objection applies, the court, if he shall think fit, shall be at liberty to make a decree saving the rights of the absent parties. But the court cannot make a decree if the rights of an absent party would be necessarily affected thereby, and objection for such a defect of parties can be made either at the hearing or in the appellate court. 4 And if the objection be made in the circuit court, the cause will be ordered to stand over in order to make new parties. 5 And if the objection be made in the appellate court, and there is merit in the cause, it will be remanded, with leave to bring in new parties. 6. 67. Parties under disabilities: infants, idiots, lunatics and married women. According to the long-established practice of the High Court of Chancery of England, infants sue by next friend, and offend by guardian ad litem. And an idiot or lunatic sues, and defends by the committee of his estate, but if there be no committee, or he be interested in the suit, the lunatic or idiot sues by next friend, and defends by guardian ad litem. The committee, if there be one, should always be a party to the suit, either as plaintiff or defendant. 7 An equity rule provides that guardians ad litem to defend a suit may be appointed by the court, or by any judge thereof, for infants or other persons who are under guardianship, or otherwise incapable to sue for themselves. All infants and other persons so. 1 Equity Rule 52. 2 House v. Mullen, 22 Wall 42, Kendig v. Dean, 97 U.S. 423. 3 Equity Rule 53. 4 Queren v. Malorden, 19 How 113, 115, Lewis v. Darling, 16 How 1. 3 West v. Randall, 2 Mason, 181, Fed. Cass. Number 17424, Bank v. Epping, 3 Woods, 391, 395. T. Lewis v. Darling, 16 How 1. 11 Daniel, 92 to 117, 219 to 248. Federal Equity Procedure. 67. Incapable may sue by their guardians, if any, or by their POC-NAMI, subject, however, to such order as the court may direct for the protection of infants and other persons. 1 In suits by a married woman, her husband should be joined in all cases where they have no conflicting interests, but if their interests are opposed she should file her bill by her next friend, and make her husband a party defendant, and where a suit is brought against a married woman, her husband should, as a rule, be joined as a party defendant too. 1 Equity Rule 87. Butler, 6 Fed. R 228, Taylor v. 21 Daniel, 118 to 172, 205 to 219, Bean Holmes, 14 Fed. R 498. V. Heath, 6 How 228, Douglas v. Ohupta, v. Place of bringing suit territorial jurisdiction. General principles. 68. Definition of jurisdiction. 69. Civil and common law classification of actions: local and transitory actions, real, personal and mixed actions. 70. Title to real estate controlled by the lex loci reicis. 71. Suits for the recovery of, or for damage to, real property, LQ Cal. 72. Same trespass quaere clausum. 73. The distinction between local and transitory actions preserved in federal procedure. 74. Same ruling in Dowelson v. Matthews approved by the United States Supreme Court. 75. Suits in equity are either local or transitory. 76. Same railroad foreclosure suits. 77. Distinction between local and transitory actions not affected by Federal Procedure Act. B. History of federal legislation on territorial jurisdiction. 78. Territorial jurisdiction controlled by federal legislation, Act of September 24, 1789. 79. Same Act of May 4, 1858. 80. Same Act of June 1, 1872. 81. Same United States Revised Statutes of 1878. 82. Same Act of March 3, 1875. 83. Same Act of March 3, 1887, and August 13, 1888. C. The present state of the law. 84. General statutes in force in relation to territorial jurisdiction. 85. Same. Equasia. Has Section 740, United States Revised Statutes, been repealed? 86. The place of being in suit, the general rule. 87. Same. When jurisdiction is based on diverse citizenship. 88. Same suits against domestic corporations. 89. Same suits against railroad corporations. 90. Same suits against national banking associations. 91. Same suits against aliens and foreign corporations. 92. Same suits arising under patent laws of the United States. 93. Same suits arising under the trademark laws of the United States. 94. Same suits under laws of the United States to protect commerce. 95. Same person suing, or sued in a representative capacity. 96. Local suits under Section 8, Act of March 3, 1875. 97. Where ancillary or dependent suits are to be brought. 98. The right to be sued in a particular district waived by general appearance. General PA 1 Noiples. 68. Definition of jurisdiction. The term jurisdiction, as applied to courts of justice, signifies 1. Primarily, the power. 76 Federale equit y proc 11 feet, dur. 69. And authority vested in them by law, to hear and determine causes, to adjudicate upon the rights of parties and the subject matter of litigation between them. This may be properly called the substantive jurisdictional power of courts. 1, and 2. The term jurisdiction signifies, secondarily, the district or territorial limits within which the power and authority of courts of justice are to be exercised, the venue of actions, or the place of bringing suits, or where suits should be brought and tried. It is called the territorial jurisdiction of courts too in discussing the jurisdiction of the federal courts, in both the textbooks, and in adjudicated cases. These two meanings or significations of the word jurisdiction have frequently been confused and confounded. This chapter will be devoted to the discussion of the territorial jurisdiction of the federal courts, or the place of bringing suit, and this matter has been kept distinct, as far as possible, from the substantive jurisdiction of the courts. 69. Civil and common law classification of actions, local and transitory actions, real, personal and mixed actions. The legal principles and doctrines which regulate and control the territorial jurisdiction of courts constitute a fundamental element in both national and international jurisprudence, and the subject has engaged the patient thought, and has been illuminated by the learning and genius of the most eminent and erudite publicists and jurists known in the history of civilization, and these principles and doctrines are closely related to the great principle that every nation has exclusive jurisdiction and sovereignty over all property, both movable and immovable, situated within its territory, and has the sole right to regulate and control its ownership, use, transfer, descent and testamentary disposition, and to administer justice in all places within its territory. In both the Roman civil law and the English common law, the principles which determined the territorial jurisdiction, or place where suits should be brought and tried, arose logically out of the inherent nature and character of the suits themselves, and became L. United States v. Arredondo, 6 Pet 691, Rhode Island v. Massachusetts, 12 Pet 657. 2 Basil v. Briggs, 9 Massachusetts, 462, Penn. Neuer v. Neff, 95 U.S. 714-748, Northern Indiana Rocco v. Mayahigan Central Arco, 15 How 240. 69, place of bringing suit 77. Permanent R&D fundamental element in those two Grammy-sized terms of jurisprudence and their derivative systems. Both the Roman and English jurisprudence divided actions into real, personal and mixed, and also into local and transitory actions, and the same distinctions and principles as to the classification of remedies pervade both systems, though there is some differences to details. One, in both state and federal courts matters of jurisdiction are largely regulated and underscore, controlled by statute, but those statutes, as a rule, must be construed and applied in the light of the nature and character of suits and the settled maxims and principles of jurisprudence in relation to the jurisdiction of courts. 2. And, as a system of remedial justice is based upon the English common law and equity systems, it is important to present a full and clear statement of the common law classification of actions, which can best be shown by statements from the common law textbooks. At common law, actions are commonly divided into criminal, or such as concern pleas of the crown, and civil, or such as concern common pleas, and these latter are again divided into real, personal and mixed actions. In a real action, the proceedings are in rem for the recovery of real property only. In a personal action, they are in pe personam for the recovery of specific articles, or of some pecuniary satisfaction or recompense, and in a mixed action they are in rem ed personam, for the recovery of real property and damages for withholding it. Personal actions are u contractu vlew delic2, being founded upon contracts, or for wrongs independently of contract. 3. In the venue, in personal actions, or county where the action is laid and intended to be tried, is local or transitory. When the action could only have RSEN in a particular county, it is local, and the venue must be laid in that county, for if it be law appointed elsewhere, the defendant may demur to the declaration, or the plaintiff, on the general issue, will be non-cited at the trial. Such are all real, and mixed actions and actions of ejectment, and trespass clausen, fregit. But where the action might have arisen in any county, as upon contracts, it is transitory, and the plaintiff may in general lay the venue where. One story on conflict of laws, Chapter 14, 31 TIDS Practice, L. Tacassi v. Adams, 102 U.S. 66. 78 Federal Equity Procedure. 69. Ever he pleases, subject, however, to its being changed by the court, if not laid in the very county where the action arose. 1. The venue is either local or transitory. If local, it must be laid, and the cause tried in the county in which the cause of action arose, or the injury was really committed. And if the venue be transitory, it may be laid in the declaration and the cause tried in any county, subject also then to its being changed by the court in some cases, if not laid in the county where the cause of action really arose. When the cause of action could only have arisen in a particular place or county, it is local and the venue must be laid therein. As in real actions, mixed actions, waste, quam impedit, or ejectment for the recovery of the season or possession of land or other real property. So actions, though merely for damages occasioned by injuries to real property, are local, as trespass on the case for nuisance, or waste, to houses, lands, watercourses, right of common ways, or other real property, unless there were some contract between the parties on which to ground an action. and if the land be out of this kingdom the plaintiff has no remedy in the English courts, at least if there be a court of justice in the country in which the land is situate to which he may resort. Where, however, an injury has been caused by an act done in OUE county, to land situate in another, or whenever the action is founded upon two or more material facts which took place in different counties, the venue may be laid in either. The venue in replevin is local. Assise/Asius on a judgment, being only a continuation of a former suit, and not an original proceeding, must be laid in the county where the venue was first laid, the defendant being supposed to reside in that county. Debt for arrears of a rent C4 against the purner of the profits, not being the original grantor, is local, the defendant being chargeable in respect of his possession, and not on the contract. In all actions for injuries ex delicto to the person, or to personal property the venue is general transitory, and may be laid in any county, though committed out of the jurisdiction of our courts, or of the king's dominions. In general, also, actions founded upon contracts are transitory, though made and were stipulated 11 TREATISE 369. 70. J. Place point A. COFB RINGINGSU at 7. 9. To be performed out of the kingdom. In an act on upon a lease for non-payment of rent or other breach of covenant, when the action is found underscored on the privity of contract, it is transitory and the venue may be laid in any county, but when the action is founded on the privity of estate it is local, and the venue must be laid in the county where the estate lies. 170. Title to real estate controlled by the lex loci citerit is an inflexible rule of the English common law, and a principle of universal application in American jurisprudence, that the acquisition and ownership of real estate, and all the means by which the title to point our real estate is transferred from one person to another, whether by deed, or judicial proceedings, or descent, or will and testament, and the construction and effect of all instruments intended to convey real property, are governed and controlled exclusively by the laws of the country or state where the property is situated. 2. And such laws, of the several states, being rules of property, are binding upon, and are followed by the federal courts. 3. And no action or suit can be maintained in one state or country to recover the title, or possession of land situated in another country or state for 11 Chitty Place. Edition 1840, 267-269. 2-story, Conflict of Laws, Chapter 10, United States v. Crosby, 7 Cranch, 115, Clark v. Graham, 6 Wheat 577, Kerr v. Moon, 9 Wheat 566, McCormick v. Sullivan, 10 Wheat 192, Brine v. Insurance Co., 96 U.S. 635, Robertson v. Pickrell, 109 U.S. 608, Alcott v. Bynum, 17 Wall 44, McGoon v. Scales, 9 Wall 23, Sneed v. Ewing, 5 Jill J. Marsh, Guy, 460, SC, 22 AM. December 47, Baxter v. Willie, 9 Vermont, 276, SC, 31 AM. December 623, Midleton v. McGrew, 23 Howe 45, Byers v. Macaulay, 149 U.S. 608. 3 Brinev. Insurance Co., 96 U.S. 635, Olcott v. Bynum, 17 Wall 44, United States v. Crosby, 7 Cranch, 115, Clark v. Graham, 6 Wheat 577, McGoon v. Scales, 9 Wall 23, Robertson v. Pickrell, 109 U.S. 608, Butts v. Muscatine, 8 Wall 575, Sheliv. Guy, 11 Wheat 361, Christie v. Pridgeon, 4 Wall 196, League v. Edgery, 24 Howe. 264, Street. John v. Chew, 12 Wheat 153, Thatcher v. Powell, 6 Wheat 119, Henderson v. Griffin, 5 Pet 151, Williamson v. Suidam, 6 Wall 723, Beauregard v. New Orleans, 18 Howe. 497, Ross v. Mlung, 6 Pet 283, Williams v. Kirtland, Towell 306, Smith v. McCann, 24 How 398, Morgan v. Curtinius, 19 Hal 8, Bondurant v. Watson, 103 US 281, Blanchard v. Brown, 3 Wall 245, Lippincott v. Mitchell, 94 US 767, Gage v. Pumpelly, 115 US 454, Ridings v. Johnson, 128 US 212, Hanrick v. Patrick, 119 US 156, Clement v. Packer, 125 US 309, Gormley v. Clark, 134 US 338, Halstead v. B11 Stir, 14 exclamation point 0 US 273, Cross v. Allen, 141 US 528, Peters v. Bain, 133 US 670, Arrowsmith v. Gleason, 129 US 86, Parker v. Dackers, 130 US 43, 4 Watts v. Waddle, 6 Pet 389, Northern Ind. R.R. Co. v. Michigan Cent. R. Ann. Co. 15 How 233, Story. 80 Federal Equity Procedure. 71, 72, 71. Suits for the recovery of, or for damage to, real property, local or real, and mixed actions are local. All actions for the recovery of the seizure and possession of land or other real property, and all actions for the recovery of damages for injuries to real property, are local, such as actions of ejectment, quer claw, suffragette, trespass or trespass on the case for nuisance, or waste, to houses, lands, watercourses, right of common ways, or other real property, and all such actions must be brought in the county or district, where the land is situated. 1. 72. Same trespass quer clause infragit, Dowson v. Matthews, by the rules of the common law, from the time of its most ancient annals down to the present time, trespass quer clause infragit, or suit for damages for trespass ethel lands, has been classed as a local action. Lord Mansfield, one of England's greatest judges, being impressed by the inconvenience and failure of justice frequently caused by not allowing this action to follow the person of the defendant, attempted to break down the classification of this action as local, and convert it into a transitory action, and he actually held in 2 cases decided by him at nisi prius, that an action might be sustained in England for trespass to land lying in the foreign dominions of the British Crown. But the influence of the learning and genius of even Lord Mansfield was not sufficient to overturn the ancient rule. In 1792 the King's Bench overruled the 2 cases decided by Lord Mansfield at nisi prius, and affirmed the ancient common law rule. That ruling was made in the case of Dowson v. Matthews, to which was an action of trespass for entering plaintiff's dwelling in Canada, and expelling him. The declaration contained 2 counts, the first for the trespass upon the land, and the second for taking away the plaintiff's goods. There was no proof to sustain the second. Conflict of Laws, Seconds 543, Massey v. Watts, 6 Cranch, 148. 11 Chitty, Pleading, edition 1840, 267. 1 Tidd's Practice, 369, Roach v. Damron, 2 Humph, 10, 425, Livingston v. Jefferson, 1 Brock 203, Fed. Cass. Number 8411, Watts v. Kinney, 6 Hill, NY, 82, American Union. Telegraph Co. v. Middleton, 80 NY, 408, Cragen v. Lovell, 88 NY 263, Northern Ind. R.R. Co. v. Michigan Cent. R.R. Co. 15 How 233, Ellen Wood, Adma, v. Mirita Cherko, 158 US 105 to 108, Story on Conflict of Laws, Seconds 538, Imo Kenna v. Fisk, 1 How 241 to 277. 24 term, Durnford and East, reports, 503. 73. J. Place. A. Said of bringing suit 81. Count, and the only question in the case was whether or not an action could be sustained in the courts of Elephant for a trespass to lands in Canada. At the trial, Lord Kenyon, Chief Justice, was clearly of opinion that the cause of action stated in the first count was local, and, there being no proof to sustain the second count, the plaintiff was not cited. A motion was made to set aside the non-suit, which the court refused, Bulair, Justice, saying, "It is now too late for us to inquire whether it were wise or politic to make a distinction between transitory and local actions. It is sufficient for the courts that the law has settled the distinction, and that an action where clause infringed is local. We may try actions here which are in their nature transitory, though arising out of a transaction abroad, but not such as are in their nature local." In an early case, the Supreme Court of Tennessee, speaking by Green, Justice, said, "This is an action of trespass for breaking and entering the plaintiff's close. In its nature it is a local action, the court of the county in which the land is situated alone having jurisdiction. In such action it is necessary that the venue be proved. A verdict will not cure a deficiency of proof. If, as argued, we were to presume that there was proof of this fact, because the jury have found a verdict affirming its existence, why might we not in every case presume there was evidence sufficient to justify the verdict? If that were so, no new trial could be obtained on account of a deficiency of proof. The record asserts that it embodies all the evidence that was given in the case. There is in it no evidence that the trespass was committed in Knox County. On that account the judgment must be reversed, and a new trial awarded. 173. The distinction between local and transitory actions preserved in federal procedure. The jurisdiction of the federal courts is derived from the federal constitution and the laws passed in pursuance thereof by Congress, but the federal statutes prescribing the place where suits shall be brought are framed upon th. theory that the distinction between local and transitory actions, and the body of legal rules arising out of such distinction, constitute an essential and fundamental L6 Loach v. Damron, 2 Humph. 10, 427. 82 Federal Equity Procedure. 7.